In a few moments, an appeals hearing will be getting underway, and we'll be looking in on the hearing throughout this video. We want you to understand how to file an appeal should you be denied unemployment insurance benefits. We'll take you through the process step by step, from filing an appeal for a hearing to having your day in court, and you'll learn how to present the best case in your defense.
We'll be going back to our appeals process soon. But first, let's talk about why the appeals process is so important. Now, as you know, unemployment insurance benefits are for people who have lost their jobs through no fault of their own, and it provides them with income until they can find new employment or be rehired by their former employers. Claimants can receive up to 26 weeks of benefits. But you also know that not everyone who applies for unemployment insurance receives it. You have to meet certain eligibility requirements, and if you don't, you could be denied unemployment benefits. For more on unemployment insurance, be sure to watch that video. Now let's go back to the appeals process.
Mr. Roberts, the one who filed the appeal, was denied unemployment benefits because he was fired for misconduct. And we'll learn what those issues are once the hearing gets started. For now, the decision's been made. What's the next step? I talked with an adjudicator who made the initial decision about denying benefits.
In the event that the claim is approved, the employer will have the right to appeal the decision, ask for reconsideration. If the employer requests reconsideration, an appeals hearing will be set up. After all, the employer is the one who pays Mr. Roberts' unemployment insurance taxes. He can't appeal the decision if he disagrees with it.
And what if the decision doesn't go Mr. Roberts' way?
Well, Mr. Roberts also has the right to file an appeal. Just remember that if he does so, he must meet our agency's required time guidelines. Appeals must be filed within 15 days of the date of mailing.
What about the employer?
An employee can go to their local office, to their local career center, or they can write to the appeals tribunal's office. That address will be a part of their decision letter.
And what about the employer?
The employer will also receive a copy of the decision letter, and they can write to the mailing address on the letter requesting that an appeal hearing be set up. Appeals hearings are set up either by telephone or in person, and both parties will be notified in writing of the date, time, and place that the hearing will be scheduled at. They will then have the opportunity to present their side of the story and also to have witnesses present who would have firsthand information about the events that led to the separation.
And that's where we are right now. In moments, the appeals hearing officer will begin hearing the facts on both sides.
I'm Carol Vanderwall, and I'm an unemployment hearing officer for the Tennessee Department of Labor and Workforce Development. I'd like to take a few minutes to discuss the rules for the hearing. First of all, everything will be recorded for the record.
Now, this about the record is an important point. Remember, an appeals hearing is a legal proceeding. All evidence surrounding the case must be entered into the official record, even though it's been said before, even though it seems unnecessary to say it again. It's needed for the record. That way, there's fairness to both sides. What the appeals officer is doing now is giving an update to both parties, explaining who requested the appeal, the employer or the claimant, and under what action of the law the appeal will be heard. This hearing is a discharge case, and the claimant, Mr. Roberts, filed the appeal.
The issue today is whether Mr. Roberts was discharged for misconduct.
What do you mean by misconduct?
Misconduct could be excessive absenteeism without good reason. It could be refusal to follow assigned orders. It could be failure to follow company policy. Now, in the case of misconduct, the employer goes first because the employer has the burden of proving misconduct. And unless willfulness is shown, that is, the claimant did wrong and knew that he was doing wrong, then the claimant may still be eligible for benefits.
Another kind of issue is what we call a voluntary quit. In that case, the claimant testifies first. The claimant is responsible for proving that there was good cause connected with work and that they should still be eligible for benefits. Good cause connected with work are things like sexual harassment, unsafe working conditions, or the failure of an employer to pay employees. Now let's go back to the hearing.
Mr. Jones, would you please explain why Mr. Roberts was discharged?
Well, according to company policy, an employee who is going to be absent is required to call in before his shift and talk to his supervisor. The rule is in the handbook that Mr. Roberts received when he was hired.
You'll notice that both the employer and claimant are representing themselves. You can choose to represent yourself, or you can have someone else represent you. Just remember, if you hire a lawyer, you're responsible for all legal expenses, but free or low-cost legal services may be available to you. So check with your local legal services or the Bar Association.
Anything else to add, Mr. Jones?
Yes, I brought a copy of the handbook. I also have a copy of the written warning and the suspension.
You can look at those documents, Mr. Roberts. Do you have any objection to their being entered as exhibits?
No.
Without objection, then, they'll be marked as exhibits 2, 3, and 4. Anything else, Mr. Jones?
Yes, I have the foreman, Mr. Smith, here to testify.
Okay, but before we get to his testimony, Mr. Roberts, do you have any questions for Mr. Jones about what he spoke about in his testimony today?
No, I don't.
Okay, we'll call in Mr. Smith then.
Let's talk again about what we've seen so far. First, the employer, Mr. Jones, brought evidence with him to support his case: the employee handbook, the written warning, and the suspension. Plus, he has a witness. Of course, all the evidence is entered into the record, and anyone who testifies is under oath. Important things to remember, but let's go back to what you can do to help prove your case. I talked earlier with the appeals hearing officer.
Well, if you have any witnesses who saw the actual event that occurred, that would be a very good person to bring with you. And if you have any documentation, such as doctor's excuses, or employers may have attendance records, copies of warnings, that sort of thing.
So we're talking witnesses, copies of warnings or any disciplinary action, employee evaluations, employee handbook, timesheets, and doctor's excuses. That's the kind of evidence you want to think about.
That would be good. But the best evidence is the actual witness who saw the event that happened.
Could I have a witness subpoenaed?
Yes, you can have them subpoenaed, but they must be, the subpoenas must be in writing and presented at least 7 days before the hearing date. But when the witnesses get those subpoenas, they will be compelled to testify at the hearing by order of the court.
Let's continue watching the appeals hearing. A witness for the employer, Mr. Jones, is ready to testify.
Mr. Jones, do you have any questions for Mr. Smith?
Yes. Mr. Smith, do you know why Mr. Roberts was discharged?
Yes, I do. On October 3rd, he did not report into work and he did not call in.
Had he been warned about that?
Yes, he had. He had received a written warning on June 3rd and was suspended for the same thing in August.
I have no further questions.
Mr. Roberts, do you have any questions for Mr. Smith?
Yeah, I do. Did you get the message that I'd called in sick?
No, no one gave me that message.
Did you ask anyone if I'd called?
That's not my job, and you know the rules. You must speak with me directly.
Weren't you busy that morning?
Mr. Roberts, I'm always busy.
Any further questions, Mr. Roberts?
No.
Thank you, Mr. Smith. We'll excuse you now.
Thank you.
Anything else, Mr. Jones?
No.
Now it's the claimant's turn to tell his side of the story. Let's see how Mr. Roberts presents his case.
All right, Mr. Roberts, tell me what happened.
Well, I did call in that last time. I was scheduled to start work at 7:30. My phone wasn't working, so I had to go down the street to use the payphone. My wife's outside, and she can verify that I left the house to make the call. I called them and told them I was sick, and they said okay. When I came to work the next day, they said I was fired.
Anything else to add, Mr. Roberts?
No, not especially.
Mr. Jones, do you have any questions for Mr. Roberts?
Yeah. What time did you say you called in?
Around 7:15.
Who did you talk to?
Can't say I know because I don't.
Well, why didn't you speak to your supervisor?
I tried. I asked for him, but he was busy, and they promised me they'd give him the message that I called.
Any other questions, Mr. Jones?
No.
Mr. Roberts, did you understand that you were supposed to speak directly with your supervisor that day?
Yeah, but I was sick, and I had to use a payphone to make the call. I didn't feel like I could wait for him to come to the phone, and the lady promised me she would give him the message.
And do you know whom you spoke with that day?
No, it was just whoever answered the phone.
Mr. Jones, do you know who might have answered the phone that morning?
No, we got 2 or 3 people who might answer the phone at that time of morning. It's not our procedure to take messages. The employees know that they have to call and talk to their supervisor.
And is there anyone who would have taken a message about who called?
No, like I said, It's not our procedure. Employees are expected to talk to their supervisors.
Mr. Roberts, did you see a doctor that day on October 10th?
No, I was better the next day. So I just came on into work rather than trying to see a doctor.
Does either of you have anything further to add?
So what happens next is this. Both the employer, Mr. Jones, and the claimant, Mr. Roberts, will get the decision by mail. If either one of them is dissatisfied with the decision, he has the right to appeal again. But it's got to be done within 15 days of the date of mailing. Instructions on how to file the appeal are also printed on the decision. Okay, let's go back up to the hearing as it wraps up.
There being nothing further, that will conclude this hearing. And both of you will receive a copy of the decision through the mail in a few weeks. And I'll keep this recorder running until you leave the hearing room.
As you can see from this hearing, making a determination can be difficult. It really depends on the evidence presented. That's why it's so important that you have documentation that supports your case and witnesses who have firsthand knowledge of the events. Let's talk now about the next step in the appeals process, and that's the right of either the claimant or the employer to appeal the decision made by the appeals hearing officer. I talked with the appeals hearing officer about the process.
You can go to your local office and file your appeal in person, or you can mail a letter to the board asking for an appeal.
Is there another hearing?
Not usually, but occasionally there is. Most of the time the board makes a decision based on the record compiled by the appeals tribunal. But if you have new evidence and a very good reason why the evidence may not have been presented before, then you can ask for another hearing at that time, and you may be granted one.
Then it's up to the Board of Review to make a decision.
At that time, yes, the board will consider all of the evidence at the board's hearing, or if there wasn't a board hearing, just whatever was in the file sent up from the appeals tribunal, and they'll make a new and independent decision. Then they'll send that decision to the parties through the mail.
And what if you're still not satisfied?
You can petition for judicial review in the Chancery Court of the county where you live, and you'll have another opportunity to have your case reviewed.
Let's stop for a moment and talk about the Board of Review. First, the Board of Review is a 3-member panel, and its job is to review decisions made by the appeals tribunal. Now, if either the employer or the claimant has come up with new evidence since the appeals tribunal hearing, he can offer that to the Board of Review. And in that case, another hearing may be scheduled. But that's strictly up to the Board of Review, and 75% of the time, there's no hearing. Let's hear more from the appeals hearing officer.
But let's say you are granted another hearing. What then?
Well, the procedure is pretty much the way it was at the appeals tribunal stage.
What about witnesses?
Yes, you can have witnesses at a Board of Review hearing. They're usually witnesses that have not testified at the appeals tribunal hearing. So if you offer witnesses who testified before, you wouldn't get another hearing. But if they're new witnesses that perhaps were not available at that last hearing, then you're more likely to get another hearing.
So, what have we learned? Let's do a quick review. First, if you're denied unemployment benefits, you have the right to appeal. If you're found eligible to receive unemployment benefits, your last employer has the right to appeal. Where does that appeal go? To the appeals tribunal. As you've learned, both you and your last employer have the right to appeal. Then you have a hearing with the appeals hearing officer. Both sides offer evidence and call witnesses. Everything is entered into the record, and as always, witnesses are under oath. The Board of Review is next. In most cases, the Board of Review makes its decisions based on what was presented to the appeals tribunal, and it doesn't hold another hearing. So that's the appeals process. If you need help or have questions, call your local office or the appeals tribunal. And of course, you can always contact the Tennessee Department of Labor and Workforce Development for more information.